Good morning, students. Today, let's discuss about Indian Judiciary System and Indian Evidence Act. With this particular session, we'll be learning about Introduction to Judicial System in India, Organizational Structure, Judicial Hierarchy, Court Procedures in Relevance with Crime and Law Enforcement, Indian Evidence Act 1872, and the basic concepts of it. What you'll be learning at the end of the session, like you'll be able to explain judicial system in India, like how the court procedure works, like what all types of cases are examined in the court, or judgment will be passed on in the court. What is a court hierarchy? It's like each state or have their own high court. At the same time, entire high courts of all the states are being monitored by Supreme Court of India. In this way, you'll be knowing what is a hierarchy of court right from the Supreme Court till the Lok Adalats that's been present on a very rural level. Then you'll be talking about legal procedures followed by court in correlation with crime and law enforcement. Introduction to Indian Evidence Act, like what Indian Evidence Act is basically about and what are the basic concepts associated with it, various types of evidences and its admissibility in the court of law. These things you'll be learning with respect to this session. First, let's know like where the judicial system falls under in our government of India. It's like we basically have three elements or a three-point element for any type of government which has been derived accordingly. So here, first one is the legislative, second one will be the executive, and the third one will be the judicial. Any government for that matter, or any government related to any type of country for that matter, will often go with these three elements which runs parallelly with each other. So an effect on any of this one parameter will affect the entire government altogether. So here today we'll be discussing about the third most important element of government, that is judicial aspect or the judicial element. Here you'll be learning about how to interpret law, what are various types of sections that are associated with various types of crimes that has to be looked into when we talk about judicial aspect, who are the magistrates, high courts, supreme courts, and when you go to the western side, they have their own Caribbean Court of Justice or private council or something as such. But then today we'll be discussing in terms of India, like how the judicial system works basically. Here you can just have a look into it, what legislative, what executive, and what the judiciary system is. And India, we have a three-tier judiciary system or a three-tier court system, wherein the main function of judiciary is to maintain law and order, whereas the other two elements of government, that is legislature, which we often call it as Lok Sabha and Rajya Sabha, and the executive, which is headed by the president, will take care of defense and the like legislative concepts of government of India, whereas the judiciary will be talking purely with respect to laws that can safeguard the basic human and fundamental rights, thereby upholding our Indian constitution system. So that's how our judiciary system works basically. Now let's talking about judiciary. Judiciary is the third branch of Indian government, as we have just discussed. Here, the supreme authority in Indian judiciary system is the Supreme Court, which is situated in Kolkata, which is later under Supreme Court, there will be high courts of each state that is being followed accordingly. Each state of entire India have their own high courts, and under each high court there will be district courts, there will be civil and criminal courts, and there will be certain revenue courts, and followed by each panchayat or a village panchayat will have nyaya panchayats or lok adalats accordingly. So this will be the overall structure how the judiciary system will be looking. So Indian judiciary system is one among the three important elements in the Constitution of India. So here we have right starting from the Supreme Court, the hierarchy drops down till to the apex court, followed by very district and taluk magistrates at the local level. At the same time, it also provides an independent and a powerful judicial system. Judiciary in India is just acts as a sole protector, as a guardian for the constitution and the fundamental rights of India, which can safeguard the overall human rights or the fundamental rights aspects of the people, wherein judiciary system acts as an important key to uphold this basic safeguarding as a guardian protector of fundamental rights looking into. Now, functions of Indian judiciary. What are functions they do when we talk about Indian judiciary system? First thing is with respect to administration of justice, like whatever the overall administration parts of the justice that's been kept, that has to be administered according to the first role that's related to Indian judiciary, followed by creation of judge and the case law associated with like you never know what type of crime often comes up or triggers up. So with evolving world around, like we often get to see various types of crime. So Indian judiciary system also comes up with laws for each type of crime that's being evolved, wherein the imprisonment or the compensation that has to be taken care will be taken care by this creation of judge or the case law accordingly. Indian judiciary system, as we have just discussed, it acts as a guardian for the constitution, like what are the basic constitutional laws or the basic fundamental rights that's been given to a citizen. So judiciary system acts as a guardian for it. And it also supervises certain functions related to the government. It also acts as an advisory function, like when government is in need of certain process or advice that has been with respect to the governing the country. It also acts as a fundamental rights protector, and it also conducts judicial inquiries for crime and criminal and civil crimes, basically. Now let's look into the hierarchy in detail. First, Supreme Court, followed by high courts in the state level. Under that, there will be subordinate courts. And when you talk about subordinate courts, it will be for each district. At the same time, it will be based upon the type of crime that's been involved. So here we have civil courts. When you talk about civil courts, any crimes, as we have discussed in our previous session, like there are certain civil crimes that can be compensated where the victim gets benefit out of it for the loss that has been incurred by the accused. So under civil courts, we have district judge, subordinate judge, the municipal court, and the court of small causes. So these are basically meant for the compensation based things. Whereas in the case of certain heinous crimes like homicide or certain large scale crimes where larger population of people are gets affected, such crimes will be often falling under criminal law or cognizable crimes, basically. So under that we have sessions court, metropolitan court, judicial magistrate of class 1, class 2, and class 3. At the same time, we have certain executive magistrates at the taluk level. So later on a department basis, for example, if there are certain civil crimes happens within the revenue department, so there will be a revenue code to take care of that. So this is purely with respect to each department. In the same way, even defense have their own code system wherein certain inquiries of internal defense part or the integral part will be taken care by the defense courts accordingly. So in this way, like we have a hierarchy that's been split up throughout. Functions of judiciary, as we have just discussed, the basic functions when you look into, like it will be with respect to decisions that's been binding to all our courts, like whatever the courts has to do, be it with respect to subordinate courts or district courts or high courts, the entire court decisions and the movements will be taken care by the Supreme Court of India. At the same time, in a state level, all the movements and the certain fundamental part restoration or the cases with respect to jurisdiction of each state will be taken care by the high court, whereas certain cases between two states will be taken care by the Supreme Court, being the supreme authority of the country. So at the same time, district court deals with the cases arising with respect to each district. In case if the dispute has not been resolved in district court, people often can approach to high court. If they feel that the judgment is not proper with respect to high court, they even have a right to go to Supreme Court for their basic right of justice that they wish to get for. Jurisdiction of High Court. This again an in detail description of jurisdiction. Here, High Court often deals with state level aspects, be it with respect to income tax, sale tax, copyright, patent rights, like whatever types of integral part associated with state government. Entire cases related to such integral part, like it will be taken care basically by this jurisdiction of High Court, followed by investigation or judgment of certain criminal cases that's been enforced by each district court, so it will be taken care by the jurisdiction of High Court. Accordingly, we have subordinate courts at district level. Under that, we have taluk courts and the Nyaya Panchayats or Lok Adalats, which often go with settlement things. So, in a presidency town, there are city civil courts and metropolitan magistrate courts. In this, often criminal crimes are being looked into. You can just have a brief look into like how the subordinate courts work with. Now let's talk about features of Indian judicial system. Like what makes an Indian judiciary system a very important one and a most third integral part of the entire government of India. First thing, Indian judicial system is single and integrated judicial system. It has its own independence of judiciary. It can make laws. It can actually look into various removal of sections or addition of sections based upon the requirement accordingly. So the judiciary basically acts as an interpreter of the constitution that's been written over. So they often perform judicial reviews on high courts for each state or have a provision of joint high courts. So Supreme Court being a supreme authority in terms of judiciary system often has a right to resolve disputes with respect to union and state courts. At the same time, it acts as a guardian for fundamental rights. It acts as a separation of judiciary from the executive, like whatever cases pertaining to this politicians that's been involved, judiciary system has a right to separate it from the executive and in order to put it for the investigation to know and to serve the proper justice for the deserved person or the country accordingly. So judiciary system has an open trial happening every month, like for each respective case. So based upon each update that's been given, ultimately the case might go in acquittal or it might go in certain imprisonment or compensation based upon the nature of the crime and the number of trials that's been made and the number of evidence that's been produced by either the plaintiff or the defendant accordingly. So at the same time, public interest litigation system, like any type of litigation that's been caused, if the public faces any type of problem, they can actually approach court for the proper justice that has to be done, that has to be got. So here, when you take the basic example, recently one of our citizen in Bangalore have reported this taking away this parked vehicles irrespective of the consent of a person. So that has been reported to the court of law, and the court of law have directed that vehicles are not supposed to be removed immediately. So this is one such improvement which shows that Indian judiciary system adds to like give an importance for the basic fundamental right of any citizen or human rights of any citizen accordingly. So you can have a look into it according to. Then components of the criminal justice system, like what all components we have, as we have discussed in our previous session, law enforcement is one such important component because all these police and the detectives or the forensic scientists that we often look into works on a basic aspect of concluding a crime with possible evidence that can support the court of law, wherein based upon which the court of law decides like what has to be done with respect to the judgment, whether the case has to go in acquittal or whether the case has to go in imprisonment, like what has to be done for any particular type of case based upon the evidence produced by law enforcement, be it with respect to police or be it with respect to this basic forensic scientist or the detective agencies who are working in line in accordance with the police. So ultimately, court takes a decision on what has to be done with respect to the judgment of each case that's been associated with, keeping reference as the evidence produced by these law enforcement agencies. So here, when we talk about judiciary system, it's quite important that we need to understand how this basic complaint structure goes. First, initially, it can be an FIR or a private complaint filed against an accused or a suspect by the plaintiff or a victim. So, based upon that, accused will be brought before the court by the police. And if the accused has accepted his mistake, then straightly it will be taken away for the conviction or with respect to the settlement that were on discussion with the victim in terms of compensation. In case if the prosecution or the advocate of the accused side does not plead guilty or does not accept the mistake that's been done, then court will direct it for the purpose of examination of accused in terms of the evidence or in terms of the statements that been made, or by directing the police for the investigation procedure. Post that, on a trial basis, ultimately court will arrive at a decision whether an accused has been proven guilty or not. So if he has proven guilty, either conviction or acquittal will be made. If he is not been proven guilty, he'll be left free, like discharging the charges, like whatever that's been put on him. So that's a basic procedure how the judiciary system works with respect to the crime. So here, when you look into the process, how a judiciary system takes up, first will be the arrest, then looking the first appearance within 72 hours, like he has to appear in the court of law. Then he'll be given a time of 30 days to look into, if he has any evidence to support his innocence or something. So after that, from 30 to 90 days, formal charges will be made, and then the arraignment, followed by early resolution. If the accused has been proven not guilty, so he can actually give his narration in the court of law, followed by pre-trial intervention, whereas even the complainant prosecutor will also have certain things to note for. So this trial process happen ultimately. Once the pre-trial is been done, a plea deal will be given accordingly. So after both plaintiff and the accused party, or a complainant and the accused advocates deposit all their evidence and everything during the trial process, finally judge will look into the overall aspect of the evidence given and the integrity of evidence given. That's when he'll take up call whether the case has to go in a conviction or it has to go in acquittal based upon the evidence with respect to both complainant and with respect to the accused accordingly. So this is the overall structure how the process takes place. So framing of charges, you can just have a look into, in case if a person accepts his mistake, what will be the charges according to the section 228 till 235. You can just have an overview into it, like date of prosecution, evidence that has been given, and after hearing accused, like if he's been proven guilty, like what type of charges given with respect to section 232. And even then, after hearing to the accused, if he doesn't agree his mistake, later based upon evidence, if he has been proven guilty, then according to section 234, like what type of prosecution acquittal charges will be laid for. So this has been explained here accordingly. Now we can just have a look into the hierarchy in terms of its importance in terms of dealing certain cases. Supreme Court, and then under that High Courts, under that basic tribunal courts or the district courts, followed by Nyaya Panchayats and the labor courts on a very rural level accordingly. So this is with respect to the courts and the judges. Supreme Court of India have a civil, 25 judges. It can be civil judge or it can be a criminal judge, whom we often call it as metropolitan magistrates. So under metropolitan magistrate, you have city civil and session courts, presidency, and the court of small causes. And under district and sessions court, you have subordinate courts, as provincial court, court of session. Under subordinate courts, you again have municipal courts and Nyaya panchayats. Whereas in court of session and the district, you have subordinate magistrate courts for each taluk, followed by panchayats and adalats. And under subordinates, again, with respect to each taluk, there will be judicial magistrate court and the executive magistrate court. This is an in brief structure, like how the judges and the courts has been distributed according to a scale from varying from the country to the local panchayats scale. So after this brief description about Indian judicial system, now let's talk about basic concepts of Indian Evidence Act and the expert testimony that's been given. So Indian Evidence Act has been introduced in the year 1872. It is basically purely deals with what all can be an evidence for the conviction, and what type of evidence has to be handled in what type of way in terms of judiciary system. All these basic aspects can be discussed over here. If you can just have a basic look into the introduction part, the term law is used in various ways in the most basic sense. It refers to any rule or law or a certain norm or certain standard discretion to which human beings must adhere with respect to the law. So that's corpus juris, or a body of law, which is basically divided into substantive laws or the adjective laws. So in the law of evidence, here when you talk about substantive and adjective law, a law of evidence is a separate entity that falls with respect to adjective law, which describes pleading and method by which the substantive law are put into operation. Here, substantive law is basically a process, whereas adjective laws are basically an evidence that is required. So this information is given as per Indian Evidence Act 1872. Now, what is the definition of an evidence as per Indian Evidence Act 1872? As per Section 3 of Indian Evidence Act 1872, an evidence can be all statements made before the court by witness about matters of fact under investigation, which the court permits or requires. Such statements are referred to as oral evidence. So, any type of statement given by witness, it's been termed as oral evidence. And on the other hand, all documents, including electronic records, presented for the inspection of the court, such materials are referred to as documentary evidence. So, any type of documentary or written or electronic records that's been present in the court as a proof, even that can be termed as an evidence in terms of documentary evidence. So here, when we look into the oral chapters, like how Indian Evidence Act has been divided, like Indian Evidence Act has been divided into three parts, and together 11 chapters are there, which comprises of 167 sections according to various types of evidence that has to be dealt with. So part one answers the question what facts may or may not be proved. Here, part one out of three parts of Indian Evidence Act, part one basically deals with facts related, whether it can be proved or not. Any facts related to a crime that has occurred, whether it can be proved or not, that will be taken care by chapter 1. Where under chapter 1, the section 1 of Indian Evidence Act to section 55 of Indian Evidence Act deals with this particular aspect. And out of the three parts, the parts 2 deals with what sort of evidence is to be given of these facts. For example, if the fact has been proven first, what type of evidence has to be given for what type of proof, as a proof for what type of facts that's been proved accordingly for each crime. So here section 56 to section 100 of Indian Evidence Act deals with the overall type of evidence that has to be produced in the court of law. Then the final part 3 of Indian Evidence Act deals with by whom and in what manner the facts are to be proved. Like who can be an expert witness and by whom and in what type he can actually prove the facts related to a crime. And for this, section 5 to section 55 and then section 56 to section 167, both part 1 and part 2 can be kept as a relevance for the admissibility in terms of evidence. So these are basic aspect how the sections are being divided accordingly. So here, when you look into this particular content here with respect to section 3, as we have discussed, we have oral evidence and documentary evidence, followed by, again, with respect to section 3, we do even have physical evidence that it can be any materialistic object which can actually act as a source of information to prove the facts associated with the crime. Such type of evidence can be termed as physical evidence, and that in order to make that as an evidence, there should be a person who is skilled enough and who has that subject knowledge enough to tell that yes, this is linked with so and so fact of the crime or a sequence of crime, which can prove the instant or the facts accordingly. So this is taken care by the section 3 of Indian Evidence Act. So here, when you talk about classification of evidence, according to Indian Evidence Act, we have direct evidence, we have circumstantial evidence. This is purely based upon relevance of evidence with respect to the probability of proving the fact. Then oral evidence, as discussed in Chapter 1 of Indian Evidence Act, documentary evidence, as discussed in Chapter 2 of Indian Evidence Act, followed by physical evidence, which can be primary and secondary evidence, as discussed in Chapter 3 accordingly. Finally, if you look at what all can be type of legal evidence, first thing, the basic principle of forensic science, that Locard's exchange principle, which you often tell that when, as we have discussed in our previous session, it's with respect to when two objects come in contact, there will be a mutual exchange of substance related to each object. So this exchange of substance will make certain proof with respect to direct or with respect to circumstantial proof. So based upon this, exchange of matter between the two evidence or two persons. There are various types of evidence that can be created. One will be the forensic evidence, which has to be examined by the expert. The other will be the expert testimony. Once the examination of done evidence will be done, like he has to prove the content that he has examined and what was the overall conclusion, then followed by the character and the hearsay, like what the victim or witness or a suspect tell or admit in the court of law, followed by various categories of forensic evidence, which falls as a main and important crucial form of evidence for any type of crime. It can be physical or non-physical evidence. It can be real or demonstrative evidence. It can be known or something new which has to be explored. Such type of evidence can also be falling under legal evidence, and it can be a class or individual evidence which can actually we can look into. Followed by all this type of evidence needs certain proof and the confirmation that yes, this can be an evidence. So only then it will be admissible in the court of law, which can be used for conviction or for an acquittal accordingly. So that's it for today's session. I hope you have enjoyed the session a lot. Thank you so much. We'll meet up in a future session with a few more exciting content with respect to crime scene and crime scene management or the law enforcement as a part of your paper. Thank you.